Hello and welcome again. We spoke last time about the malfeasance, which is not an occasional unfortunate happenstance of our judicial system, but which characterises the entire edifice from top to bottom. There are disconcerting signs that the criminals who have seized control of our governance are ramping up their crimes, which prompts questions. The first would be, are those purporting to be the government unaware of the lawful system of governance established and protected under the 1215 Magna Carta, the primary document of the British Constitution? A yes answer would seem scarcely credible. We must assume that these individuals are aware of the true nature of our law and are therefore deliberately concealing that nature from the general population. Very clear evidence of this can be seen when we examine this document, displayed on a website claiming to be representative of the Commonwealth of Australia, as an educational tool enabling people to gain a better understanding of how our system of laws operates. We observe in the very first sentence what can only be described as a deliberate falsehood, for only three types of law, inverted commas, are mentioned: statute, delegated, and common law. Nowhere in the document is there a mention of constitutional law, yet this is in fact the only law that is truly defined as such, and under which all other laws must be subjugated. Two of the three types mentioned by the PEO, the Parliamentary Education Office, statute and delegated, are in fact merely legislation. And the definition given to common law, namely that it is formed over time by the decisions of judges in individual cases and is always overridden by statute law, is so inaccurate as to constitute a deliberate and deplorable misrepresentation. Common law has existed for thousands of years in all parts of the world and varies according to local cultures and mores. In the case of the British Commonwealth, this common law was based upon the Ten Commandments, or the Golden Rule, and early monarchs such as Alfred the Great understood that these laws, which were unwritten, were nevertheless consented to by every person possessing a working conscience. Any statute laws would have to be in accordance with this common law, which was not an agglomeration of decisions made by judges, like an ever-growing pile of bird droppings on a sundial, but a conscientiously assembled outcome of the decisions of jurors trying their peers for infractions of the common law, not the random dictates of renegade monarchs or parliaments. Indeed, there were no parliaments when King John was tried by his peers for extremely serious crimes and informed that in future everyone was to be under the law, which became the Constitution of England with the sealing of Magna Carta in 1215. This constitutional law, which the PEO deliberately omits from its description of how law works in Australia, is in fact the law which overrides all other types because it binds the government. When a government is established, it is given the monopoly on the use of force when it comes to upholding the law as defined by the people through the jury system. Obviously, such power must be strictly controlled, lest either well-meaning but incompetent, or worse, persons of harmful intent abuse this responsibility and become the most serious threat to the peace and liberty of the subjects. Thus, the Parliament is not supreme, as indicated in this duplicitous publication. It is the Constitution that is supreme. Our alleged government is fond of dosing the sleepy populace with contaminated definitions of our society as a democracy, which it is not. A democracy established by voting or suffrage is merely a dictatorship of the majority, especially meaningless if major political parties concur on how to abuse the people. A true democracy, as we've already shown, is formed when the jury is able to exercise its power of annulment of unjust legislation. Even prosecution of incompetent or unscrupulous legislators, and thus prevent the government becoming a runaway train of arrogant buffoons drunk on power. There is a little-known word for such a government, which fits most admirably when applied to those operating in Australia, and especially Western Australia. The word is Cachistocracy, K-A-K-I-S-T-O-C-R-A-C-Y. It means a society being administered by the least competent, the least well-qualified, and the least morally principled people in the community. Only a couple of days ago, we were treated to the unedifying spectacle of Premier Mark McGowan, alongside compromised henchman Police Commissioner Cole Blanche, announcing further unlawful infringements of basic human rights by instituting random searches of vehicles at Western Australia's hypothetical state borders. Let's recall firstly that there are no actual state borders in Australia. It is one country with free travel throughout, provided for by whichever constitution one cares to nominate. We'll concern ourselves with the true constitution, that of the British Commonwealth, which allows all subjects freedom of movement throughout their countries, apart from areas to do with national security, etc. McGowan and Blanche's weak arguments for this unjustifiable intrusion and the imposition of search without warrants or probable cause is that they noticed a reduction in the amount of illicit drug importation and associated crime during the illegal COVID lockdowns and border closures. The two amigos claim that imposing these infringements on people will make WA a safer place with less crime. On the face of it, an appealing proposition for people who are asleep at the wheel of guarding their own and their children's liberties. However, we live under a constitution which charges Crown subjects to be self-governing and provides for a jury system to judge the guilt or innocence of people after they have been apprehended committing a crime. There is no lawful mechanism for acting under the assumption of presumed guilt, as we have seen more than once in Article 39 of Magna Carta. Of course, people may commit crimes, everyone knows the basic laws, and some purposely transgress them. That is why we have police, to apprehend and bring before a jury those thus charged. In our Cachistocracy, unfortunately, we have the alleged authorities openly violating constitutional law, aided and abetted by a privately funded militia dressed up in police costumes, who spend virtually all of their time on the job deliberately ignoring their constables' oaths and unlawfully harassing law-abiding subjects. Perhaps if instead of pursuing these unlawful corporation-motivated revenue-raising activities, the police actually did their proper job of detecting and arresting real criminals, these new proposed infractions of our rights would not be necessary. Perhaps if the profit motive for drug trafficking were seriously reduced or eliminated, the drugs would still be used, but without the attendant crime caused by the high prices to be paid for the substances of choice. Other addictive, legally available drugs, for example alcohol and tobacco, are either ignored or used sensibly by many of the community, and comparatively little crime attends their use. If our Cachistocrats were more competent, they would find other ways to reduce crime than by treating all subjects as though guilty in breach of the law. Yes, Messrs. McGowan and Blanche, we could prevent virtually all crime by simply locking people into cells. Or perhaps neighbourhoods with 15-minute boundaries. Now there's a thought. I wonder if there are any advanced plans for that up their deceptive sleeves. Such philosophies and edicts are the very antithesis of liberty or a free society. Indeed, what could even be termed a human existence. Yet with freedom comes responsibility. The responsibility to make decisions without outsourcing vital functions to others, especially to those who want to exercise control. The responsibility to stand up for one's rights and liberties, and those of our families, when threatened with oppression. We currently see far too many people asking despairingly, what can they do? More people might find disgust to be a more useful and motivating emotion than despair. Disgust might motivate more people to seek out the truth about their rights, the law, and what they actually can do. The odious actions and proposals of McGowan and his cronies are worthy receptacles into which to pour our disgust at their treason, their total disrespect for human rights, and their utter lawlessness. Meanwhile, we are increasingly assailed by a corrupt and unlawful corporate police force. In WA, Australian business number 91724684688, which has no Crown authority and operates solely to make profits for those who are the shareholders, and to browbeat those who dare to speak out against the ubiquitous corruption. There is evidence now that these felons are becoming more aware and uneasy about the number of people openly questioning their authority, and are becoming increasingly violent and belligerent in their responses to what are perfectly legitimate questions about their rights to behave as they are doing. There are scripts in existence which we have touched upon in the past, giving us the appropriate responses when engaged by these fake constables. A link will be in the comments box to the constitutional caution card, and there are other scripts available from the Telegram channel, MC 1215 Knowledge Centre AU, a link to which is also included. Recently, however, there is evidence that many of these corporate hired thugs are unwilling to listen to any cautions or answer any questions, and are seeking any excuse to damage vehicles or commit assaults, often without provocation. There are numerous videos online showing this type of illegal behaviour, and the advice at this time is to be as diplomatic as possible with these uniformed hoons. They will soon have virtually no support from the law-abiding public as their crimes become more readily observable. I recommend carrying a laminated copy of Article 61, the full text, in one's glove box, together with a full copy of any files of notices which might be relevant to a type of encounter we might expect, for example, traffic matters or mandates about wearing masks, etc. The first point to remember is to always film the interaction. By all means, attempt to question politely the officers as to their authority, but if they don't want to listen, offer them the copy of Article 61 to read, explaining that apart from the common law to which we all consent, and which doesn't have to be written down as acts or statutes, this is the entire extent of the law in the British Commonwealth as it now stands. explain that the copy points out that any instruction or quoted act which attempts to prevent us carrying out our instructions under our oaths of allegiance is null and void, and that if enforced, will result in the officer being held personally liable. If that still elicits a belligerent response, one may say something like, "I have explained the law to you, officers, and if you are determined to proceed with unlawful demands or orders, you have identified yourselves as armed offenders, for which you will eventually have to answer in your unlimited personal liability. As you are armed, I won't be resisting, but will comply with your demands under duress, and matters will be sorted in due course according to law." The bottom line is that the courts and the judges know of Article 61 and cannot afford to be seen openly committing treason or sedition. Yes, we may have crimes committed against us, but we must stand firm and await our day when we have these criminals in court. Thank you for watching.